Welcome, everyone. On behalf of the Indian Legal Program, I'd like to welcome you to our annual Canby Lecture. My name is Patty Ferguson Bonney. I'm the Faculty Director of the Indian Legal Program and a member of the Pointe-au-Tremont Indian Tribe. As many of you know, the Indian Legal Program is a center of academic excellence at ASU Law, and we take great pride in our program's faculty, staff, and students. We also value our tribal neighbors and our partnerships. We acknowledge that the law school is located on the lands of the Akimel O'odham, and further acknowledge that Arizona is home to 22 tribal nations that comprise 27% of the state's land base. ASU Law recognizes the sovereignty of these nations and seeks to foster an environment of success and possibility for Native American students. Since our founding, the law school has been committed to scholarship, service, and teaching in the areas of Indian law and tribal law, and we pledge to continue and expand this work. This annual lecture is part of that commitment. In 2007, our colleague, Professor Robert N. Clinton, founded this lecture to honor the Honorable William C. Canby for his many contributions to Indian country, his highly distinguished service to the bench and bar, and his commitment to teaching Indian law. Judge Canby is one of the founding faculty members of this law school. Soon after he started teaching, the BIA asked him to provide legal training to Arizona tribal judges, and he began meeting with them once a month. He laid the foundation for the ILP by teaching the first Indian law course over 50 years ago, and by creating an informal office of Indian law in order to engage tribes and respond to the needs of the Indian community. This foundation set in motion the eventual formation of the Indian Legal Program. Judge Canby was appointed to the Ninth Circuit Court of Appeals in 1980, and since that time, he has continued to support the ILP as a member of the Advisory Council, and he also continues to write in the area of Indian law. Judge Canby is the author of the American Indian Law in a Nutshell, and we're honored to have Judge Canby here with us today. I'd like to thank Judge Canby and his wife, Jane, for their continued support of the Indian Legal Program. I'd also like to thank the Advisory Council, our alumni, students, faculty, and staff for your support and participation in this lecture. I'd also like to acknowledge and welcome this year's lecturer, Kristen Carpenter. We're excited for your talk, and I'm really looking forward to it. At this time, I'd like to turn it over to my colleague, Trevor Reed, to introduce our distinguished speaker.
Well, thank you, Professor Ferguson Bonney. After the lecture concludes, we'll be pleased to hear some comments from Judge Canby, and then we'll have a few minutes for your questions from the audience. And you're welcome to use the Q&A function on your Zoom page throughout the lecture to enter those questions, and I'll go ahead and read those aloud when the time comes. Don't be shy. We're thrilled to have Professor Carpenter, who's taken the time to be with us today, and your questions will only add to the conversation. Now, it's my distinct honor to introduce our Judge William C. Canby Jr. lecturer. Professor Kristen Carpenter has led a remarkable career advocating for Indigenous people's rights in the United States and around the world through her scholarship, her advocacy, and her public service. After graduating cum laude from Dartmouth College and Harvard Law, Professor Carpenter served as a clerk to the Honorable John C. Porfirio of the 10th Circuit, followed by practice at the venerable Boston firm Hill and Barlow. But it wasn't long before Professor Carpenter returned to legal academia, ultimately joining the faculty of the University of Colorado Law School in 2009. During her tenure at CU Boulder, Professor Carpenter has served as Associate Dean for Research, Associate Dean for Faculty Development, and she's currently Counsel Tree Professor of Law and Director of the American Indian Law Program at Colorado Law. Professor Carpenter's scholarship has been tremendously impactful for many of us working at the intersections of Indigenous people's law and human rights, especially regarding land, culture, and religion. Her dozens of publications and several books are bold and intellectually rigorous, interrupting debates and reframing conversations over complex and sometimes deeply charged issues like sacred sites protections, cultural appropriation, Indigenous religious freedom, and migration. But Professor Carpenter's work isn't just academic. She is globally recognized as a leader on the implementation of Indigenous rights. She recently concluded her second term as a member of the United Nations Expert Mechanism on the Rights of Indigenous Peoples from 2017 through 2021, including a stint as chair from 2019 through 2020. And while serving at the UN, Professor Carpenter worked on human rights issues regarding Indigenous peoples from around the world, including Brazil, Canada, Democratic Republic of Congo, Finland, Japan, Mexico, Russia, South Africa, Sweden, Thailand, and other locales. Professor Carpenter helped advance the recently declared United Nations International Decade of Indigenous Languages, which we are currently in the midst of, and now she continues her work in collaboration with the Native American Rights Fund on a project to realize the aims of the UN Declaration on the Rights of Indigenous Peoples here in the US. This project has provided innovative training and resources to help tribal, federal, and state leaders work together to advance Indigenous human rights, including the recently published Tribal Implementation Toolkit, which I strongly recommend everyone check out. She frequently works with Indigenous communities, museums, universities, cultural and religious organizations, national and local governments to help advance understanding of Indigenous people's rights. And she currently sits on the bench of the Shawnee Nation's High Court. Now, I consider myself very fortunate to have known Professor Carpenter for a number of years now. In fact, her memorable talk at Columbia University while I was a student there on Indigenous human rights law sparked in me a desire to become a law professor someday. Her mentorship and encouragement has had a similar impact on many people throughout the world and throughout our field. So it's my sincere pleasure to introduce Professor Carpenter as the 14th Judge William C. Canby Jr. Lecturer. Please join me in welcoming Professor Carpenter.
Well, good afternoon, and thank you, Trevor, for the incredibly kind introduction. I really appreciate it and have so much respect for your work and your collegiality, so thank you. I'd also like to acknowledge all of the Arizona State University students who are hopefully tuning in online, and thank you for being here. I am joining you from Boulder, Colorado, and these are the traditional lands of the Arapaho, Cheyenne, and Ute people. And I also want to thank so many friends and colleagues at Arizona State for having me, including Stacy Leeds, Bob Miller, Patty Ferguson-Bonney, Kate Rosier, Derek Beetso, Danielle Williams, Teresa Bolio, who made this event possible, and some of the colleagues who were at ASU previously and really helped to develop this program into the powerhouse that it is, including Bob Clinton and Kevin Gover and Rebecca Sosi. I would also like to thank my parents who are watching online and my children who are hopefully not watching online because they should be in school. And my wonderful co-author, Professor Angela Riley, with whom none of this work would really be possible as we often work together. And my partner, Alexei Sikarev, who's an Indigenous human rights activist in Russia as well, for his support. It is an honor for me to give the William C. Canby Lecture. I, like everyone who has ever studied federal Indian law, am deeply familiar with the nutshell and its important roles in helping legitimate our field for the bench and bar. This publication, in its many editions, has also helped make federal Indian law accessible for tribal lawyers themselves. And I think in this regard, it has really served as a tool in the quest for access for justice. I met Judge Canby just a few times personally when the American Law Institute was engaged in its restatement of American Indian law, and really appreciated the seriousness of purpose that he brought to the project. Importantly for today, I note that Judge Canby and his wife, Mrs. Canby, have a significant history in international work, especially in Ethiopia, Eritrea, and Uganda, including in the Peace Corps and helping to negotiate peace after conflict. While we witness traumatic events occurring around the world today and try to maintain our collective sense of humanity, I want to honor this work and a serious commitment to peace and understanding as a point of departure from my work and my remarks today. The central thesis of my talk is that it is time for the world to embrace a human rights approach to remedy the past oppression of Indigenous peoples and to ensure their collective freedom and flourishing in the future. And this includes the United States, where we need to advance tribal calls to implement the UN Declaration on the Rights of Indigenous Peoples. In this regard, we can learn from what other Indigenous peoples globally are doing to implement the Declaration in their home countries and discuss opportunities for us here. This presentation draws from my work at the United Nations, as Professor Reed mentioned, and then shares some examples from the implementation project, a joint initiative with the Native American Rights Fund and University of Colorado that I co-lead with Sue Noe, an attorney at NARV. I will conclude with some thoughts about the future. First, why would those of us who have devoted our careers to American Indian law, Alaska Native, and Native Hawaiian rights look to international law? And I think there are two sets of answers. And as this set of images probably makes clear, in some respects, the answer is already apparent from practice. Indigenous peoples are in international settings, advocating for a number of matters. So the choice is not whether to go, but how to advocate effectively there. But as we step back and think about those engagements, I think we could group them into two types. So certain matters are international by nature. You might recall a few years ago when the Hopi tribe found out that its sacred kachinas were being put up for auction in Paris. Or just a couple of days ago when Native Hawaiians were in Germany seeking the repatriation of human remains of their relatives. I have worked, as I'm sure many of you have, with some of the tribes in Arizona, Tohono O'odham and the Yaqui people, whose territories span the US-Mexico border, such that international legal engagements happen almost every day for some of those folks as they're trying to cross the border to meet relatives, visit sacred sites, even go to the grocery store. Some work that both Trevor Reed and Angela Riley have been involved in is the protection of intellectual property, which, like many other intangible resources, cannot be confined in the United States. If a song is on the internet, if a prayer has been recorded, there is a challenge for Indigenous peoples in the US to protect that resource and a necessity to avail themselves of international protections. I could go through this list and you can read it as well, but all of these natures are ones that require tribal lawyers to be conversant and in fact expert in international law to meet the needs of their clients. A second set of matters where I think international law is important, and especially the UN Declaration on the Rights of Indigenous Peoples, concerns those matters where federal Indian law's standards really fall short of universal human rights norms. You may recall just a couple of, actually it was in 2013, in the adoptive couple versus baby girl case, where the US Supreme Court really narrowly interpreted the Indian Child Welfare Act such that a Cherokee child, a little girl, was removed from her perfectly capable, fit, and loving father and placed with a white family, violating fundamental rights to family, to culture, to personality, and so on. As people, again, in Arizona surely know, we have a very difficult set of precedents on American Indian religious freedoms, such that the Supreme Court has held that the federal government may destroy American Indian sacred sites, even if it would virtually destroy the religion. Stated another way, American Indians really don't have freedom of religion in the United States. And although some of those cases are 20 or 30 years old, they're being applied currently, for example, in the struggle to protect Oak Flat, an Apache sacred site, from development. The rest of this list also identifies areas where US law falls short of basic human rights. So I've talked about the right to family, the right to religion, the right to land too, and equality associated with property, is also a basic human right recognized in international law, where tribal property should be accorded the same respect as everybody else's property, but that's not the case in our legal system currently. When I was working on some of these cases in the 2000s, it was really that moment of getting to the end of the line in the federal legal system that motivated me to go back to the international human rights system. And it wasn't entirely new for me because I had studied with Jim Anaya and Rob Williams as a student, but it was when tribal leaders would receive these decisions back from the Supreme Court and then say, well, now what are we going to do? They couldn't give up on the welfare of their children or their ability to practice their religion just because the Supreme Court said it was the end of the line. And in fact, it wasn't the end of the line. And it turns out that Indigenous peoples have been going to international institutions, the League of Nations and the United Nations, since they were founded. And this has become a 100-year legacy of international advocacy that we can really draw upon as we're thinking about where we want to take the next steps in our work with Indigenous peoples. It's always a very humbling experience to me when I go to tribal nations, and Trevor mentioned some of this, and I think I'm there to teach them about the UN. And they say something like, well, actually our tribal leader so-and-so went there in 1920 or 1940 or 1960, and we had a meeting at the ceremonial grounds and decided to get involved. We brought this treaty-based case in the 1960s, before you were even born, where we were advocating, let's say, for land protection or gender rights or some other fundamental human rights. And I think, well, of course you did. And I should have known that legacy went so far back. And I think and hope it would be a really wonderful project to trace the legal history of Indigenous peoples at the UN. And I think it's really no surprise as we think about it that Indigenous peoples have been going to the United Nations. This is our main international institution devoted to peace, humanity, and security. The UN was founded in 1945 at the end of World War II to provide protection for minority people, especially around religion, but also the right to life, to survive as peoples against majority oppression and sometimes against state oppression. And of course, Indigenous peoples would seek to participate in that system to protect their own rights and to act in solidarity with others who have sought also to advance peace, humanity, and security. In that spirit of solidarity, I'd like to observe that there are millions of Indigenous peoples across the globe. The population estimates differ, but these are folks who, along with American Indians from the United States, have been going to the UN to advocate for the cause. And they're really distributed around the world. And one of the incredible joys of my experience at the UN was meeting Indigenous people, whether it was San people from South Africa, or Sami people from Norway, or Mapuche people from Chile, or you name it, Aboriginal people from Australia, and so on, and finding out that across such incredible differences of geography, economy, politics, that Indigenous peoples really do have so much in common in terms of culture and in terms of shared concerns around human rights. And so this amazing group of people, and you may recognize in some of the earlier pictures Oren Lyons from the Onondaga people, Thomas Banyaka from the Hopi people, Philip Deere from Muskogee Creek Nation, and then in this picture, Jim Anaya from the United States. So many folks ended up working on this global project to advance Indigenous peoples' rights and to make the call for a declaration on the rights of Indigenous peoples that would specifically contextualize universal human rights in the Indigenous peoples' context. So we've said already that it's a universal right. It's recognized in the Universal Declaration on Human Rights that everybody has the right to religion. Everybody has the right to life. Everybody has the right to family. But what does that mean in an Indigenous peoples context? Well, when it comes to the right of religion, and it concerns sacred sites that have been taken away from Indigenous peoples during times of conquest, it has something to do with use rights, with restitution, with acknowledgement. When it comes to family and Indian child welfare concerns, those rights, as articulated in the Declaration, have to do with keeping families together and providing them with the support that they need to recover from intergenerational trauma. We could go through the whole list of international human rights. I think a key one to understand for our conversation is also the right to life, because in many settings, the right to life is argued and thought of in terms of individual rights. For example, in death penalty cases or torture cases. For Indigenous peoples, the right to life also plays out in those circumstances, but also a collective right to life, a right to stay alive, to flourish, to thrive as Indigenous peoples, as collective peoples. And so after decades of advocacy, Indigenous peoples were successful in this effort. And the UN General Assembly voted by an overwhelming majority to adopt the UN Declaration on the Rights of Indigenous Peoples in 2007. And this is one of those things that I never thought would happen during my lifetime. There was a draft declaration that we cited throughout the 1990s and 2000s. But in one of those fundamental leaps on the trajectory of justice, the General Assembly did vote in favor. There's a small error on the slide. It should say 144 to 4 to 11. Unfortunately, among the 4 nations originally voting against the declaration was the United States. But as the bottom bullet says, the United States did get on board just 3 years later, realizing the error of its ways and joining the rest of the world community in this expression of support for universal human rights in the Indigenous peoples context. The declaration is a resolution of the General Assembly. It was adopted by vote instead of signed like a treaty. And it's best understood as an authoritative expression of a global consensus on minimum standards for human rights in the Indigenous peoples context, as we've said. In terms of a bit more content, Article 7 conveys the right that I was just mentioning in terms of the right to life. Indigenous peoples have the collective right to live in freedom, in peace and security as distinct peoples. And I think this is so powerful, especially when we reflect on where we are in federal Indian law, where we actually have very few affirmative statements of Indigenous peoples or American Indian tribes' right to exist. We actually have, to the almost very contrary, the doctrine of federal plenary power, which has extended as far as the federal right to terminate the existence of tribes. Now that's a most extreme example, and it hasn't happened in a couple of decades, but it remains on the books, that there are few limits on federal power, and in fact that there are few affirmative statements of this right of collective survival. There are other categories of rights enumerated in the Declaration. Some are very broad, as in self-determination and equality. Others are very particularized, such as the right to political representation, to religion, to language, to free, prior, and informed consent, and so on. I'll come back to some of these rights when we talk about specific cases. And I don't want to keep the whole conversation in the abstract, but I did want you to have some initial orientation. I usually keep my UN Declaration on the Rights of Indigenous Peoples booklet in front of me, and I require my students to always have it with them. So I encourage all of you to either pull up your hand copy or look it up online if you'd like to follow along with this part of the discussion. Oh, sorry, one more point here. The Declaration is, I think, so comprehensive and addresses so many of the gaps and challenges that we have in federal Indian law and that many brothers and sisters have around the globe. And this is not by accident. It's because of that legal history I just mentioned to you, where Indigenous peoples were actively involved in the discussion, in the drafting, and the negotiation of these rights. This is not a top-down document that somebody at the United Nations decided to write up. This is a bottom-up document that Indigenous peoples, advocates, people we or our parents or grandparents knew, worked to articulate. And I'm always reminded of that when John Echohawk, the executive director of the Native American Rights Fund, says, the Declaration has everything we want in it. And for John, who's a very reserved, longtime advocate, I think that's such a powerful statement for this moment in federal Indian law. But there's kind of a counter narrative that I want to unpack a little bit that comes up when those of us who are deeply involved in this work try to move towards implementing the Declaration, as Trevor said. And what we often hear is, but it's not binding. And for me, as a law professor, I have to say this is a nails on chalkboard moment because, well, for a number of reasons that I will belabor for a moment. So first of all, to say that this instrument, this statement that has now been supported by 193 nations of the United Nations, that is all of them, including the United States, is not binding, I think really disrespects the monumental achievement of Indigenous peoples who worked towards its drafting and its adoption, as well as the states who took the action to vote in favor of it or later to express support for it. Even worse than that, perhaps, to call this instrument non-binding or aspirational, which is what the US State Department likes to do, is to relegate Indigenous rights to a lower status than everybody else in the world enjoys. And remember, these are supposed to be universal human rights. And when the United States describes these as just aspirational, one read is that everybody else has rights and Indigenous peoples only have hopes. The Mohawk diplomat Kenneth Deere has described this as fundamentally unfair and in fact racist for other people to have universal human rights and Indigenous people only to have aspirations. Putting on my law professor hat to say the UN Declaration is not binding is simply imprecise. I don't know if we're talking about international law or domestic law. As a matter of international law, this is a declaration versus a treaty. It's implemented through an entire framework of diplomacy, which I'll talk about in a moment, versus a monitoring body. This is really getting into the weeds. But if we're talking about its binding nature, we should be specific about whether we're discussing international law, where, as I said, there is an entire framework to realize its promises, and domestic law, which is even more technical in that every country has its own standard for determining whether international law is enforceable in that country. Some countries, let's say Germany, are monist states, where if there's an international treaty, it becomes automatically effective nationally. In the United States, we have more of a dualist system where something has to occur legislatively for any international instrument to become part of our law. And in that respect, this question is almost freeing, because even if we have a very formal treaty or covenant, we still have to go through the same process in the United States to domesticate it. So that argument also isn't terribly persuasive to me. It's also very clear from the US Supreme Court in cases like Roper versus Simmons that looking at international law and comparative law is something that the judiciary can and does do, especially when trying to ascertain fundamental human rights. The Roper case was one where the Supreme Court was examining the constitutionality of the juvenile death penalty and looked to international law, the Covenant on Civil and Political Rights, and comparative practice to see that no other countries were executing children who had committed crimes, and the United States didn't really want to be in the company of Yemen and a handful of others that were committing human rights violations. The same thing could happen in this context, right? The US Supreme Court could look at the declaration and say, you know what, we don't really want to be one of the only countries that's violating Indigenous people's religious freedoms, notwithstanding our First Amendment. And finally, I realize my nails on chalkboard moment is probably itself becoming nails on chalkboard, but I think the oft repeated statement that the declaration is not binding is an excuse. It's an excuse for the United States itself to not implement its provisions, even though it has promised to do so. And it's an excuse for lawyers who don't want to do the really difficult work of understanding international law. US law schools typically don't teach it as well as they should. In Indian law, sometimes we haven't taught it as well as we should. And we need to do better. We all need to understand the process and the substance of international law as it impacts Indigenous peoples. And I'm not sure if he's on, but Professor Bob Miller, I'm looking at you. You're on the ASU faculty and an expert in Indigenous peoples in international law. And I'm really happy that your students there have a chance to learn from you. Finally, on the binding point, and here I really want to offer an update to the conventional wisdom. The declaration has actually been adopted in a number of jurisdictions. And I was looking back at past Canby lectures and I saw that the late Bill Rice, whom so many of us admired, gave the Canby lecture in, I think, 2015, before this major shift to the implementation movement. And so in some ways, this is an update to his amazing lecture. And I love the fact that the implementation movement is being led by tribes themselves, including tribes in the United States. So the Muskogee Creek Nation in 2016 decided to translate the declaration into the Muskogee language. And you see in this picture, Miko George Thompson, Chimona Deere, Yoni Spencer, as well as the Principal Chief David Hill, Judge Greg Bigler. And I got to sit with them sometimes when they were working on the project of translation. And I think the motivation there was really about a local tribal governance issue that they were having, that people trying to participate in the ceremonial life of the tribe just to get to the stomp dance on Saturday night or harvest ceremonial medicines were being harassed in the local community. And they were looking to federal law, to state law, and there was nothing that was really a fit. But then they looked at Article 31 of the Declaration and Article 8 of the Declaration that provide affirmative protections for culture, for traditional knowledge, for plants, and decided to take that declaration, put it into the Muskogee language so that it would be culturally meaningful and accessible to traditional people, and then passed it by tribal resolution. Other jurisdictions have done the same. Mexico City, just sort of like Washington, D.C., in that it's a federal district, in 2017, adopted all 47 articles of the Declaration into their constitution. Mexico City has, I think, 8.8 million people who are now all subject to the provisions of the Declaration. Canada, our very friendly neighbor to the north, in 2021, after having been pushed by Indigenous people there, passed national legislation to bring the whole body of Canadian law into alignment with the Declaration. These are things, this is happening. The Declaration is going to be realized. It is being realized. We're not quite there in the US, but you can see where this is leading. Some pictures sort of jurisdictionally or territorially, I do want to recall that the fact that the Declaration, and I abbreviated it as the MDRIP because it's the Muskogee Declaration on the Rights of Indigenous Peoples. The fact that it's tribal law, it's the law of the jurisdiction in the Muskogee Creek Nation, means that it's the law of a significant portion of Oklahoma following the McGirt case, right? This is potentially transformative. And I think there may be some judges from the Muskogee Creek Nation who are on this lecture, and I'm sure they realize the opportunity they have to apply this declaration, as well as in Mexico City, and the entire jurisdiction of Canada is obviously a very significant one. Beyond those places where the declaration has been legislatively adopted, it has also been applied by the high courts in several countries, and then inspired ensuing administrative reform. Perhaps the most notable example concerns the Maya people of Belize, who for a very long time argued that their traditional land tenure should be protected as property under the Belize Constitution. Now, this is a case that has a lot of resonance for us here in the United States, where, as we know, tribes' Aboriginal title is not fully protected under the Fifth Amendment. Going back to the Tehitan case, that rule has made it very difficult for the Western Shoshone to remain in their homeland. There are current cases about lithium mining that are again bringing that up, the Western Shoshone's ability to reside peacefully on their lands without interference. And when this case went through the Inter-American Commission of Human Rights, the Caribbean Court of Justice, and finally the Belize Supreme Court, one of the fundamental citations was to Article 26 of the UN Declaration, which provides that Indigenous peoples have a right to their land, whether it's traditionally owned, used, or occupied, and not necessarily requiring title under the dominant laws of the nation. This jurisprudence has gone through the entire Inter-American system, which means all 35 or so countries of the Americas, but hasn't gotten really to the United States yet, although there is one case where I think it might be going in that direction. For those of you who are participating in the Land Back movement in the United States, this is an incredibly powerful article of the Declaration that can give source and substance and spirit to your arguments for restitution of the land itself, or if that's not possible, for monetary damages, which hopefully could be used to reacquire other lands. To accelerate a little bit, I think these examples I've shown are all part and parcel of this move to implementation. And in 2014, we really saw a turning point where the UN General Assembly, again, and here by consensus, all 193 countries agreed by consensus to commit themselves to implementing the declaration. So one interesting point when the United States keeps saying, well, this is just an aspirational document and it doesn't have any legally binding provisions, the United States has also committed to legal reform in partnership with Indigenous people to make its laws consistent with the Declaration. So I think a better question than is the Declaration binding is to ask, how do we implement it? This is an international human rights instrument. There is an entire body of law and scholarship that concerns the implementation of international human rights instruments domestically, including in the United States. And with my co-author, Angela Riley, I wrote this article several years ago where we looked at the process of implementation as it was already applying in the Indigenous peoples context in the United States. And we noted that implementation of international law always has a domestic component. It can't occur at the UN by itself. It must include discourse, negotiation, diplomacy between international bodies and nation states. In our case, of course, also with Indigenous peoples or tribal governments. And so this multiple site model for implementation is one that we were observing already, as I said, in 2014-15, and that we have continued to encourage as tribes move forward in implementation. At the UN, so let's talk about the international part of this. I mentioned that we don't have a treaty or a monitoring body for implementation of the Declaration, but we do have an infrastructure around Indigenous peoples' rights. And as Trevor mentioned, I served on one of these three bodies, the Expert Mechanism on the Rights of Indigenous Peoples, which received a new mandate in 2016 at the urging of Indigenous peoples themselves to help Indigenous peoples, states, and other parties realize the aims of the Declaration. And our mandate was to use dialogue, expertise, coordination, all of the tools of diplomacy to encourage, to pressure compliance and implementation with the Declaration. A quick snapshot, and I won't have time to do too much of a travel log, but I do want to share some of the places that I was fortunate enough to visit and some of the projects we worked on. So the expert mechanism is comprised of 7 worldwide appointees of the Human Rights Council. I was the one from North America, as you can see, and I was joined by a member from the Arctic, from Russia and the Transcaucasus, from Asia, from the Pacific, from Africa, and from Latin America. And this was an incredible cohort to work with to advance implementation of the Declaration worldwide, to learn from each other, to elevate the discourse, to share a commonness of purpose with the UN in Geneva as our home base. And I'd like to talk just briefly about some of the ways in which we found it possible to advance the aims of the Declaration through dialogue and advice. And this is a smattering of examples, each of them incredibly important in its own right, each of which had years of history before we ever got involved. But again, by way of example, the Ainu people of Japan had long themselves identified as Indigenous peoples through their own language, their own customs, their traditions. And for over a decade had argued for the Japanese government to recognize them as an Indigenous people. And it was finally in this move to implementation that the Ainu people cited the Declaration in a national legislative process and it secured what we would call federal recognition by the Japanese government of their peoplehood and then their ensuing rights and their claims to things like repatriation and land and so on. In some of the other examples that we worked on, in Thailand, we made Emirates' first visit to Asia. And this was a sobering visit in many ways. We were in Chiang Mai, Thailand. And although we weren't there on a fact-finding mission, some of the Karen people from Keng Kracheng National Forest came to talk to us about the fact that they were being evicted from a national park, and not only evicted without ending land rights, but some of their activists were being disappeared and even murdered. And we used that opportunity to talk again about the rights to be free from violence, to land, to culture, and so on. And ultimately, although the government had really shut down any awareness of this really severe set of events, there was a modicum of accountability. And this is now part of a discourse on Indigenous people's rights in Thailand that previously didn't exist before. Now, I don't want to say the UN was responsible for that. The advocates on the ground were responsible for it, but they decided to bring it to us. We worked with them to amplify it. And I think in this process of human rights implementation, it is possible and important to work collectively together. In South Africa in 2019, the Khoisan people, who are often called the first humans, they may be the oldest humans in terms of their bloodline and genealogy in South Africa, they had long been using rooibos tea for healing and for nutrition, but it was exploited by the tea industry with no acknowledgement, no compensation, and further environmental devastation to them. Using Article 31 of the Declaration with respect to traditional knowledge, they negotiated a benefit sharing and credit and acknowledgement, as well as fund to repurchase land with the rooibos industry. It wasn't a perfect agreement, but it was something that they were very proud of and shared with us when we went to visit, and then we in turn tried to amplify. I should say, if she's on here, that Professor Stacy Leeds was in South Africa with us for another portion of the trip, where we were working on understanding Indigenous people's land rights across the globe. And I was really happy to have her engagement. In one of the final matters before my term on Emirates was over, Indigenous people in Brazil asked us to give advice to the Brazilian government regarding their rights to health during the COVID pandemic. And one thing that we saw around the world is that many countries used pandemic as an excuse for further violations of Indigenous people's rights, kind of a distraction. And especially the Indigenous people of the Amazon, Yanomami and others, really experienced, like many people did in the US, the diminishment of their population, high death rates, high infection rates. And so again, using the Declaration, using its provisions on self-determination, on language, on health, and so on, we provided some guidance in cooperation with the Indigenous representatives and the Brazilian government, which did cooperate, even though it's not always friendly to Indigenous peoples, on guidance for meeting Indigenous people's basic human rights during COVID. These are only, as I said, a few of the examples that I worked on, and I'll come to some of the US points now. Perhaps the million-dollar question for those of us who are really concerned with American Indian rights in the United States is, well, how do we do all of this here? Or how do we do a version of it here in our own country? And again, I go back to the model that I advanced a number of years ago with Angela. And that model has been taken up and informs the implementation project, which is a joint endeavor of the University of Colorado and the Native American Rights Fund. And we have worked in partnership with UCLA Law School and a number of tribes to take those international lessons and bring them home. And of course, we have as models, some of those examples I already mentioned. The Muskogee Creek Nation has been out in front of many of us for a number of years. Navajo Nation, same. So it's not like we're inventing something new, but we're trying to draw from those lessons, make them more apparent, and provide additional resources and advocacy to continue this work. I didn't provide links because I didn't think that would be useful, but if you'd like to Google the implementation project, you can learn more about it. So a few examples that we identified in our tribal implementation toolkit, and some of them hopefully will strike close to home in a good way in Arizona. So some tribes, Muskogee Creek Nation, adopted the Declaration as law. Others passed resolutions and are passing resolutions indicating their support for the Declaration. And I think the very first to do so was Gila River Indian Community in Arizona, which approved by tribal resolution the Declaration, and in fact used the language of ratification, which is a very powerful concept in implementation because it suggests some internal process that's accepting that as law. The Navajo Nation, as I mentioned, goes back through its Human Rights Commission, and it has its own whole infrastructure for taking a human rights approach to Indian law matters. And it has been applying the Declaration in its reports and its hearings for well over a decade now, probably getting, I mean, almost since its origin. And one of the things that I love about the Navajo Nation Human Rights Commission is that it applies the Declaration in kind of a seamless web with tribal law, which is often articulated in the Navajo language in terms of clan responsibilities, and federal law, for example, on anti-discrimination or state law, and the Declaration itself to really articulate a jurisprudence, a Navajo human rights jurisprudence going back to the fundamental law, and to do so in everyday employment discrimination cases all the way up to the sacred site cases going to the Supreme Court. A few other examples here. The Ho-Chunk Tribal Code is another great example where the Ho-Chunk Nation didn't adopt the entirety of the Declaration, but looked at two particular articles, 13 and 14, which concern language rights, and said, we're going to adopt these as a matter of tribal law and recognize that people have a right to use their own language, the Ho-Chunk language, in tribal law and processes. And then I love this second provision where the Ho-Chunk Nation declared its own policy of anti-discrimination against other minorities within their jurisdiction under the International Covenant on Civil and Political Rights. And I love this provision in part because people will ask, well, are Indigenous peoples only the beneficiaries of human rights law, or do they also have obligations? And here's the Ho-Chunk Nation saying, we are going to respect the rights of other minorities within our borders. And I think that is such a powerful example. The Yurok tribe has pulled from Article 26, which I mentioned previously, to affirm its rights and interest to conserve and protect the tribal habitat. In a landmark event, Fawn Sharp, acting in her tribal leader capacity there at the Quinault Nation, which with other tribes negotiated an agreement around free, prior, and informed consent, such that the Attorney General's office in Washington would no longer do just check the box consultations with tribes, but actually also receive their free, prior, and informed consent before taking measures that would affect them. And I oftentimes give entire lectures just on free, prior, and informed consent, and this is potentially, one of the signature aspects of the Declaration in terms of reform in the United States, because so many tribal leaders as clients and us as attorneys complain about that consultation where the federal government or state governments will say, well, we'll consult with you, tribe, but we won't actually take any substantive direction based on the consultation. This provision, Article 19 of the Declaration, would change that and set a higher bar. And I think it has, already some really significant traction along those lines. In terms of the courts, so remember I said courts can cite international law. They don't have to, but they can. And in one exciting case involving Hemos Pueblo, and this was an early stage of the litigation, so I don't want to overstate the importance. It was also a footnote. But the Federal District Court in New Mexico cited the Declaration in an Aboriginal, a case concerning Aboriginal title. And this goes back to that set of cases about Indigenous people's own laws, customs, and traditions, giving rise to cognizable property rights. That bridge we haven't quite crossed yet in the United States. And just the fact that a federal court is citing the Declaration in an area where we have such historic injustice gives me hope for that area of law. And maybe also in the Oak Flat case, where US law is clearly so below the standard of the Declaration. Maybe advocates could cite and courts would even consult the Declaration when it comes to the religious freedoms of the Apache people, noting that if the sacred site is destroyed, in this case, it would be impossible for Apache people to have their girls coming of age ceremonies to protect and practice their religion there. Okay, I'm coming to the end of my time, so I'm going to make just a couple of more points. Those were all tribal law examples. Well, what about encouraging our federal government to do what Canada has done, and that is to implement the Declaration more broadly? We've already seen some actions in federal departments and agencies, the State Department, EPA, the Advisory Council on Historic Preservation. They all actually have internal policies on the Declaration. If you're practicing in any of those agencies, you should just Google the policy and cite it as a matter of internal agency practice. What I would like to see is the White House Council on Native American Affairs call on all agencies to develop an internal policy on the Declaration, ensuring compliance and reporting on it annually. Tribal governments, however, have asked the federal government to do much more than agency compliance, to develop an overall national action plan, to appoint an ambassador on global Indigenous affairs, to participate in the International Decade on Indigenous Languages, and to encourage tribal participation as tribal governments in the United Nations. I'm hopeful that the federal government will eke towards that, but it's going to take a lot of work. Finally, Indigenous peoples in the United States are increasingly participating at the UN itself. So I talked about tribal actions, national advocacy, and now international advocacy. The World Intellectual Property Organization has for 20 years been working on 3 instruments to protect, hopefully, Indigenous people's own traditional knowledge, cultural expressions, and genetic resources. Many advocates from the United States have been participating in the Indigenous Peoples Caucus to make sure that some of those interests that I mentioned earlier that can't be confined to US borders will be protected internationally. And this has taken a lot of time, energy, and resources, and hopefully is being reinvigorated now. There's a new venue in the United Nations in the climate change framework where Indigenous peoples are participating. There's Daly Sambo from the Inuit people in Alaska, as well as Andrea Carmen from the Yaqui people in Arizona, going to make sure that Indigenous people's own concerns are going to be taken into account when the Convention of the Parties, the climate change conventions, are discussed, further negotiated, and applied. In one really important example, again, of relevance to Arizona, and this is one I worked on when I was at the United Nations, the Yaqui people of both Arizona and Sonora made a request to the expert mechanism for assistance under the declaration with repatriation of their sacred masakova, a consecrated deer head that is used ceremonially, cared for by the Kalencias, and had been removed from the community in the 1930s by Danish anthropologists and kept in a museum in Sweden for all of that time. And MRIP accepted that engagement, and we then embarked on a 2-year process of facilitating dialogue between the cross-border Yaqui people and the government of Sweden through its National Museum, resulting in what we think is the first agreement to repatriate not to a national government, but to the Indigenous peoples themselves. And even though there is, I mean, obviously in the US, we have NAGPRA, which is fabulous, but it doesn't apply internationally. Internationally, we have the UNESCO Convention against trafficking and for repatriation, but that's a state-to-state matter, and it doesn't ensure that Indigenous peoples have a seat at the table. The actual repatriation has been delayed because of COVID, like everything, but this is a really substantial diplomatic outcome where I hold my hands up to the Yaqui people, and also where the states, where Sweden, Mexico, and support were willing to participate. So for all of you law students out there and others who might be interested in international law, there is so much for you to do. You can read the works of Walter Echohawk, Jim Anaya. You can attend the UN Permanent Forum on Indigenous Issues coming up soon. One, I guess, sort of silver lining to COVID is that those sessions are now available online. You can zoom in, you can watch, you can listen to the diplomacy, the rhetoric, and after sort of gaining some familiarity, you can start to participate. There's a wonderful fellowship in Geneva for Indigenous peoples and minority peoples that some of our Indigenous advocates have gone through, and I would really encourage students, young professionals, others to take those opportunities to get involved. There are also these positions at the Permanent Forum at MRIP where those of you with more experience might consider putting your hat in the ring and having the opportunity to advance our rights, Indigenous people's rights, I should say, in those venues. So in conclusion, I'll say that in a world of peace and justice, Indigenous peoples would have the right to live in freedom and peace, not be subjected to violence, have the ability to love and raise their children at home. Indigenous peoples would have the right to revitalize and use their languages. They would have the right to practice their religion, to maintain their sacred lands. Here in the United States, we're not living in that world. Indigenous peoples don't have those rights yet. But I'm hopeful that through the solidarity and energy and commitment of the Indigenous peoples movement, by addressing ourselves to the implementation of the Declaration, we can create that world and come to inhabit it, hopefully in my lifetime, but certainly in your lifetimes. Thank you very much. I appreciate it.
Thank you so much, Professor Carpenter. Such a moving and remarkable presentation, going through so much of what we have to hope for in terms of implementation of the UN Declaration. I know we have a few questions in the chat, but before we get into that, I'd like to go ahead and turn the time over to Judge William C. Canby Jr. for a quick moment to provide some commentary.
Thank you. Well, my thanks to Professor Carpenter. That was really a remarkable lecture, and maybe I needed it more than most people, because I'd been in the sort of traditional Indian law framework for a long time, and the way we handle that in sort of writing up our doctrine and describing what the law is, it's all case oriented, or usually early statute oriented. And we look for positive law, and we soon run into that the nail scratching, blackboard scratching problem of, is this enforceable? And I think that there are a couple of really important things that Professor Carpenter said that indicate that people like me and the rest of the courts, but more important, others in the political system, really need to open their eyes to the Indigenous rights movement and to the developments in it. In the first place, just looking at what tribes' problems are, if we've needed any reminder that our system is a global system and that problems are global problems and opportunities are global opportunities, I think the last couple of years have completely obliterated that kind of insularity. Talk about climate change. Well, that affects tribes just as much and sometimes more than all other people. When I think of the importance, let's say, of a declaration and of the people who are trying to implement, the hardest nut to crack, probably in the United States, is the court system. If you get into actual litigation of a specific issue, the courts tend to look for positive law and then enforce it. A treaty, which is a statute, has the force of a statute or a case, an authoritative case, but usually we don't have the authoritative case. But we do interpret legislation, and legislatures have a lot of freedom. We interpret regulations, and we give a lot of deference to agencies that have a lot of discretion in what kind of policies they provide. And sometimes agencies would just as soon do the right thing, but they need some support that gives both protection and encouragement. And that's why a declaration representing virtually worldwide unanimity and the support of many people like Professor Carpenter, who are working to get the declaration recognized and made a part of the policy of the legislative and administrative structure, then we may be able to get the courts to come along, because then you'll have an agency regulation, you'll have some legislation. And in those places where there's some wiggle room for a court decision, the fact that there's a UN declaration in support of one course of action instead of another, I think that will increasingly have its effect. So I can't do anything but praise the work that Professor Carpenter has done, and also congratulate her on an amazingly informative lecture. And I can't believe that she timed it to the minute. I've seldom seen anybody put together such a cohesive package and deliver it so well. Thank you, Professor Carpenter.
Thank you. And if I could just say, I'm truly honored, Judge Canby. I really admire you, and your kind words and your thoughtful words mean a lot. So thank you very much.
Well, we have a few questions in the queue, and of course, please go ahead and type those into the Q&A function on your Zoom screen there. So the first question comes from Joel Klein and asks, how does the International Labor Organization Convention 169, if at all, fit into the puzzle of implementing Indigenous rights in the United States? Is it a useful tool for Indigenous peoples in the US to push for, or do you think the focus should stay on the UN Declaration on the Rights of Indigenous Peoples?
Thank you, Joel. That's a great question. And I had such an interesting relationship with the International Labor Organization when I was at the United Nations. So for those who don't know, the International Labor Organization is an independent agency within the UN, and it's a tripartite body where states, workers, and other constituents have a role. And it has long actually had some of the earliest treaties specific to Indigenous peoples' rights. So there was ILO 107 going back to the assimilation era, and then ILO 169 that was adopted in 1989. And in Latin America, this is a very important treaty. 22 countries worldwide have adopted it, and many of them are in Latin America, although a few Nordic states as well. And to the extent that Indigenous peoples, are often in any national economy, they are often a very significant portion of the labor force, and their interests and concerns around labor, I think, motivated ILO 169. And it does have binding effect in all of those states, depending on how they handle international law. And it has some good substantive provisions. Where I kind of got into it with ILO was around this issue of free, prior, and informed consent. And we, MRIP, encouraged ILO 169 to take its provisions on consultation and working towards consent and interpret them consistent with the declaration, which has more forceful provisions. The ILO didn't really want to do that because they thought it might scare off some states from adopting it, from entering into the treaty regime. The United States hasn't adopted it. Here's where I'm going to be a little less optimistic and maybe more pragmatic. I think the chances of the US adopting a labor treaty are pretty slim, and especially doing so 30-something years after it was promulgated. And some of the provisions, although powerful, could be updated, as I just mentioned. Now, it would be great if the US became a party and could encourage the US to interpret it through the lens of the declaration, but it's tricky. And I guess in direct response to your question, I would like to focus the efforts on implementing the declaration, which seem very timely to me at the moment.
Thank you. The next question is from Roy Miller, and the question says, should Indigenous peoples in the United States have rights that other American citizens do not currently have?
Great question, and this is one of our fundamental questions of federal Indian law, I think, in which in the United States, we have often talked about Indian law exceptionalism and a certain set of doctrines that in some ways seem specialized to the situation of American Indian tribes, and arguably justified because of the history of oppression, of subordination, of displacement, and dispossession. And some of those actually come up in the realm of plenary power, where the federal government can enact legislation for the benefit of tribes and tribal members at a lower level of scrutiny rational basis review instead of strict scrutiny as it would for racial minorities, and that's based on the political status of tribes. So a few answers against that backdrop. I absolutely do believe in the universality of human rights. I think that human beings are human beings, and it is hard for me from a principled or experiential perspective to say that one human being, based on their race or their religion or whatever it is entitled to a different level of protection for the right to life or the right to family or the right to religion. But those rights, as I said, need to be contextualized to each situation. And in the United States, the situation of American Indians is very particularized. That's one of the reasons why we have the political status of tribes, where we have some remedial statutes. There is no other people, collective people in the United States that has that political relationship, that has gone through land dispossession, and it is absolutely appropriate to recognize the context for political participation, for the right to life, which I keep harping on, the right to children, and so on, in that context. And so I will insist on both things, the universality of human rights and the particular context in which American Indians find themselves, which require particularized remedies.
Well, thank you. The next question reads, have there been efforts to domesticate the Declaration via congressional action, or has the executive branch mainly focused on this issue through the State Department?
Yeah, so far mainly through the State Department. And I didn't say too much about the Obama administration, although maybe I should have. So it was during the Obama administration when the president reversed the US's previous position on the Declaration, expressing support for it. And I should give credit to Kim Teehee, who's the Cherokee Nation's delegate to Congress, but was then inside the Obama administration, really working with tribal leaders to cultivate the administration's support for the Declaration. The State Department then issued its statement on the status of the Declaration, which is, in my view, sort of like liability limiting statement that I don't love, but it can be updated and it can be built upon. It's now 11 years old. And then as I said, some of the agencies have developed their own guidance, and I was really happy to see Judge Canby underscore that as important, because some of that guidance is amazing. It's fabulous. It uses free, prior, and informed consent. It uses the substantive provisions of the Declaration. But all of that wind up in the executive branch is to say there has not, to my knowledge, been any meaningful or any measure that's had traction to adopt legislation like there is in Canada to either create a national action plan or a statute to adopt the Declaration wholesale. I think there's a lot of consideration of strategy around that, but it hasn't happened yet.
All right, and I have one question here from Daniel Faddis, who says, what education rights are given through the UN Declaration?
Thank you. Well, in Article 14 and 15, and again, I hope you all have your declarations there, Indigenous peoples do have they have the right to an education, a basic right to an education. And also they have the right to have their histories taught as part of the national education, which I think is very important and possibly transformative in the United States, where even some of my law students said, well, we never knew about treaty violations or the Trail of Tears or these other events. So the right to have Indigenous histories taught, and also the right to be educated in one's tribal language. And I think that is a very important, complicated set of considerations in the International Decade of Indigenous Languages, which I'm glad you mentioned, Professor Reed, because that was one of the things that was taken away from tribes, their ability to educate their young people in their own languages. And that meant the language itself diminished, in some cases went dormant. but also the kind of knowledge, the traditional knowledge, the names for plants and medicines and ceremonies and know-how, all diminished. And that right to be educated in one's own language is something we really need to figure out in this decade, and especially in the plurilingual world that we live in, where people's access to a multiplicity of languages is going to just benefit them and benefit our society very broadly.
Well, wonderful. Professor Carpenter, it's been such a pleasure to be able to have you with us. And we're very much excited to be able to continue to work on this. And we look forward to, of course, continuing the conversation. As you saw in the chat box, this lecture will be available online. And of course, we'd love to hear from you all in response. And we look forward to, of course, seeing you at many more ASU events going forward. Thanks once again, Professor Carpenter. We'll go ahead and close.
Thank you, Professor Reed. I appreciate it.